Hi, my name is Quinn, and I'm a student at the Indigenous Community Legal Clinic, also known as the ICLC, in downtown Vancouver. This video has been recorded on the unceded ancestral territory of the Musqueam, Tsleil-Waututh, and Solo nations. This video is part of the Live Law series on Federal Indian Day School, or IDS, class action settlement claims. As a reminder, IDS claims are due by July 13th, 2022. This video is about busting some of the common myths we hear about the IDS claims process. I recognize that this video might come across as very law-heavy and directive. Unfortunately, the reality is that the IDS claims process is colonial and bureaucratic. We wish this were different. In these videos, we're trying to give you the information you need to increase your chances of a successful claim. But at the end of the day, we want to emphasize that this is your claim. It's your decision what to disclose, what harm level to apply for, and how to draft your narrative. The ICLC is here to help, but you're in charge. I want to take a moment to acknowledge that the IDS claims process can be difficult and emotionally demanding. As you work on your claim, take care of yourself and seek out any support that might be helpful to you. A reminder that free counseling is available 24/7 from the Hope for Wellness Helpline at 1-855-242-3310. Now I will turn to some common myths about the IDS claims process. Myth 1. If I registered for the day school class action, then I don't need to do anything else to apply for compensation. What's actually the case? Registering for the IDS class action is not the same as making a claim for compensation through the IDS settlement process. To make a claim for compensation, you need to complete and submit the claim form. For more on this, see the video in this series called Preparing Your Claim. Myth 2. If I submit a claim, I'm going to have to defend my claim in front of people. What's actually the case? The IDS claims process is 100% confidential. No one but the claims administrator will read it. You will never be directly questioned or cross-examined on what you're submitting, or need to appear in person before any sort of judge or body. In the case of a reassessment, you might be asked for more information or supporting documents, but that's it. Once the claims process is complete, you can even choose to have your application destroyed. There's a spot for you to indicate this on the claims form. Myth 3. I can't submit a claim because I don't have a status number, a social insurance number, or a government ID. What's actually the case? If you don't have any of these things, you can still submit a claim. So to submit a claim, you do not need to first apply for Indian status, government ID, or a SIN. Instead, you'll just complete Part 6 of the claim form, which asks you to swear in front of a guarantor that the information in the application is true to the best of your knowledge. Your guarantor can be a notary, a commissioner of oaths, an elected official, a community leader like a chief or a counselor, or someone from a designated profession, like a doctor, dentist, or lawyer. Your guarantor does not need to read your application, so it can stay confidential. Myth 4. I'm only eligible for a harm level 1 claim. What's actually the case? Most people might actually be eligible for a higher harm level and more compensation than they think. Remember that if your claim is assessed to be a harm level 1, you get $10,000. With a harm level 2, you get $50,000. Level 3, $100,000. Level 4, $150,000. And level 5, $200,000. Given that it can potentially make a difference of thousands of dollars, it's worth taking the time to figure out if you might be eligible for a higher harm level. However, it can be hard to make sense of the harm levels charged. To figure out what harm level to claim, we encourage you to make an appointment at the ICLC by calling the intake line or by dropping in person. Since applying for a harm level 1 is less work than applying for any of the higher harm levels, you may also want to just submit a level 1 and be done with it. If that is what you want, that's totally okay. However, keep in mind that the process is designed to funnel people towards applying for a level 1 instead of a higher harm level and more compensation. And this is because the more people who apply for a level 1, the less money that needs to be paid out to survivors. Although applying for a harm level 2, 3, 4, or 5 may seem daunting, the ICLC is here to help you for free. We know that having to choose a harm level sucks, and we wish the claims process didn't involve so many hoops. Myth 5. If I apply for a harm level greater than 1, and the claims administrator decides that I am not eligible for that harm level, then I will get no compensation. What's actually the case? There's no risk in applying for a higher harm level, although it may be more emotionally demanding. If your claims administrator thinks that your claim is a lower harm level than what you indicated, they won't deny your claim, but they'll just reassess your harm to be at a different harm level. That said, there's nothing lost to be applying for a higher harm, as long as your application is detailed and supported. Myth 6. The IDS claims process is so easy that anyone can do it without help. What's actually the case? We've heard lots of talk that the IDS claims process is easy. However, based on our experience with the ICLC, unless you're applying for a harm level 1, the claims process isn't that straightforward. It takes time and work to put together a detailed narrative, to track down school records, and to get other supporting documents. We wish the process was more straightforward, but that's just not the reality. We've seen that having someone familiar with the claims process to help you to prepare your claim and to advocate for you can make a difference. The ICLC is here to help you at no cost in a way that respects that you're in charge. To close, in this video, we've busted some common myths about the IDS claims process. Here are the key takeaways. Registering for the day school class action is not the same as applying for compensation. Your claim is confidential, and you won't need to defend your claim in front of anyone. You don't need Indian status, a social insurance number, or a government ID to submit a claim. You may be eligible for a higher harm level than you think, and there's no risk in applying for a higher harm level. The claims process is not as easy or straightforward as some people think. In preparing your claim, it's a good idea to work with a lawyer, an advocate, or someone who's familiar with the claims process. For assistance with your IDS claim, you can reach the ICLC by calling the intake line at 604-822-1311 or by dropping in at our location. We're at 148 Alexander Street in Gastown. As a final reminder, please take care of yourself and get the support you need as you prepare your Indian Day School claim. The process can be draining and even traumatic, but it can also be a source of healing and justice. We wish you all the best.
All Live Law Project content is provided by law students for informational purposes only. It is not and should not be considered legal advice. We're not suggesting that you make legal decisions based on any content included as part of this project without seeking legal or other professional advice. We cannot guarantee the accuracy of our content. The information in this project may not apply to you if you don't live in British Columbia or if the law has changed.